I'm David Tullis, and I'm here with Christopher Sapp, who is our Eagle Radio Network Mid-State Bureau Chief. We are Eagle Radio reporters, and Chris, we are very concerned about and writing about a trial that's coming this Tuesday of Brenda. Miss Brenda. Brenda Simpson of Savannah, Tennessee. That's Hardin County. She's going on trial on Tuesday. What is it that we're seeing in our early report? I'll be posting something on Monday after getting comment from DA Neil Thompson. What are the issues that are stark and damning?
From what I'm understanding, she's being denied the ability to obtain subpoenas from the court, or she's having problems getting the clerk of court to issue subpoenas for some of the witnesses that she would like to call. She is wanting to summon the Commissioner of Safety and the Commissioner of Revenue to give evidence in her case with regard to the address that supposedly all of her notices were sent to. Under the Apex Doctrine, however, the state will not allow those individuals to be summoned on her behalf, and she's going to have to try to obtain subpoenas for junior executive level people such as the IT staff or the mailroom supervisor, and she's going to have to try to get that done Monday.
Which is not going to be possible to do. The main issue is that she's being criminally charged on 3 counts with driving and operating a motor vehicle, though what is her main position on whether she's a driver and operator or not?
Well, from what I understand her to say is that she allowed her license to expire because she did not want to be engaged in the privilege anymore. And just like having a real estate license, a barber license, some type of other occupational type license, she did not use the automobile in the course of her employment or for, as an Uber Lyft driver, pizza driver, or, somebody that would require a driver license. So, because she allowed that to expire, she subsequently received a citation of belief and understanding, and they subsequently convicted her by sending revocation notices to a former stale address that the state had on file. And we believe that she may have the state may have known of other addresses, and she's going to have to argue that.
But she has no counsel, and she has overall kind of a feeble personal presentation and doesn't make arguments in a full legal way, but she just makes statements, and that's going to be against her. So if she goes to trial on Tuesday, Christopher Sapp, it looks for sure that she'll be convicted, even though she's making a very good point. She does not have the means of delivery of it, and of course the other side is counting on that. But the point about suspension of a license after it has expired, why is that suggestive of a fraud by the state?
Well, the driver license is like any other contract. Think of it like a newspaper subscription or cable TV subscription. You buy the newspaper subscription for a year at a time. Well, at the end of that subscription can expire and run out, and if you're no longer a user of those services, they can't come back and try to suspend you later for reading the newspaper or reading a book or whatever else that you somehow acquire through another means or another avenue. In Miss Brenda's instance, she's not in the driving taxable type privilege that requires a license, but she does believe that she has an inalienable right to use the roads as long as she doesn't harm or injure any other person.
In her arraignment or preliminary hearing October 18, she pointed that out in a statement she made. She made it by special appearance, and she argued no subject matter jurisdiction because the court was an improper court on the grounds that the Commissioner of Safety is the proper court. And she used the phrase, she was not involved in a privileged taxable activity. And that's a key phrase in this whole debate is, are you involved in the activity subject to the privilege? Simply using your car for errands, mercy trips, as she was doing on another occasion, or taking care of necessaries or performing her Christian duties, those are not subject to taxation or regulation or registration or anything or licensure, because they are by right, and she's not doing the taxable activity. What is the taxable activity that is in the presumption of the state's case against her?
The taxable activity is that she's hauling goods or persons for hire or in the course of her duties of employment, and that's a presumption in law that the state is making, and she's stating emphatically and under oath and affidavit, paying a penalty of perjury, that she's not engaged in that type of activity, or she would obtain a license. She's done her reading of the law. She understands privilege as the courts of Tennessee have defined that, and she's not engaged in that. So it's going to be interesting to see what happens Tuesday morning. If they do get a conviction, she's going to have a more arduous uphill battle on appeal. She really needs to try to get a stay prior to the trial and get her subpoenas that way. It's going to be much easier for her to argue to the Tennessee Criminal Court of Appeals under Rule 10 to possibly get an emergency stay.
We're concerned about the right of ingress, egress, the right of enjoyment of the people's roads, the free use of the public right of way. That's what Chris and I are concerned about for her and for you.